Welcome guys. This is going to be a summary video for Unit 1 Area of Study 2, Proving Guilt. So for this topic, you are going to need to know these 7 key knowledge areas. So I guess use this slide as a checklist as you go through the videos. What you want to make sure is you know all of these concepts in detail before working into your assessment task to feel confident that you'll do well. So starting off with this video, we're going to be focusing on the purposes of criminal law, what the presumption of innocence is, and some of our key concepts of criminal law, which is, if you're doing legal studies in year 12, they all continue on into year 12 legal studies. So I thought I would just throw this out here as a quick first reminder for this SAC. What you definitely need to know is what each of the task words are and what they require you to do. So for this SAC, I predict that it's very common that you're going to see words like distinguish and also words like discuss and explain. So for example, just make sure if you were to get a distinguished word asking you in a question, you really want to make sure that you're telling me the difference between something. So for example, if I'm asking you to distinguish between a summary and indictable offense, what you want to say is, what is the difference or a key difference between a summary and indictable offense? So just keep this in mind as you go through your studies. So to start off with our 4 purposes of criminal law, and I'll deep dive into them. So the first purpose we have is that we want to protect individuals. So one of the main reasons we have our criminal law is we want to have processes primarily to deal with people who commit crimes. So basically we want to have laws in place and that we have some kind of law to punish that person if they break the law. So obviously if we didn't have laws for murder, people would be able to get away with killing other people and we wouldn't have very safe individuals in our society. Our second one, nice and straightforward, is we want to protect people's property. So we want to protect both a combination of privately and public property, and that's things like our land and environment. So that's why we have laws against trespassing, because we don't want people to go onto our private property. We don't want people evading a business's space or anything like that. So that's why we have those 2 in place. Moving on, our criminal law, we want to, in general, protect our society as a whole. So that's why we have laws in the first place. We want to set up guidelines and expectations to basically indicate to people what don't we tolerate in our system, and I guess what are we trying to clearly stamp out. So that's why, for example, in Victoria, we have very strict rules in relation to drug trafficking, drug possession, because they want to stamp out that kind of behavior in our community. And our last purpose we have is that we need to promote justice. So what this basically means is that if someone does break the law, we need to have some kind of way to enforce that law and hand down a punishment. So in criminal law, the main thing you look at is what's known as a sanction. So when someone does break a criminal law, you're primarily going to see them be sent to jail, given a fine, or provided with a community corrections order or community service. So we obviously want to punish people when they do the wrong thing, and as a result we hopefully provide justice for both our community and victims of crime and that sort of thing. So that's the first key knowledge area done. This one is a nice straightforward one, a little bit about the presumption of innocence. So in terms of what you can get asked about this is why the presumption of innocence is so important, or how is the presumption of innocence relevant to a specific case study you might be provided. But like it is, it's pretty straightforward, doesn't need much explanation. But our burden of proof basically means that our prosecution must prove your guilt, and you're basically considered innocent until they do so. So the prosecution has the responsibility to bring forward all the evidence, paint the picture or paint the case against you, and until they have successfully proved that you have done a crime without any doubt in mind, then you're always presumed innocent. So it's a really important principle we have, similar to something like the right to silence, to help protect our individual rights. Alrighty. Moving on to our key principles of criminal law. So these 5 areas are really important because you'll sort of see them again and again throughout the entire year of legal studies, but also they're very common to pop up in year 12. So if you nail them now, it can make life a lot easier. So you need to know these 5 concepts in detail. Generally what you'll get is you'll get given a case study and it might say something like who has the burden of proof in this case, or what would the standard of proof be in this case. So you generally won't get asked to define them, you'll get asked to apply your knowledge to a specific piece of stimulus or case study. So starting off with the first one, every single crime in Victoria or Australia has two main elements, or two key things they need to have. These are both Latin words. So the first one is actus reus, which basically refers to the guilty action. And the second element is what's known as the mens rea, which is known as the guilty mind. So when you combine these two things together, that is what makes our crime. So what I mean by that is a guilty act is going to be the physical action someone does to commit the crime. So for example, what we want to think about is it's the act that causes the consequence of a crime. So for example, if you stab someone, that is the actus reus. If you poison someone, that is the actus reus. And what we need to make sure is that we're proving this action has been occurred by the prosecution once again. So they need to prove what was the actual conduct, what was the actual cause, and what was the outcome of whatever happened that proved that this was the guilty action in a crime. Pretty straightforward. Moving on to the mens rea, this one is a little bit more confusing, but basically just think about what's going on in someone's mind at the time of the crime. So what is the mental element of the crime? The most common one you'll probably see is something like someone's intention to commit a crime. So what that might mean is someone might be planning out to murder someone for 2 weeks. That clearly shows that they had intent or intention to commit the crime. Or another one might be reckless indifference, that you know that by stabbing someone, even for example in the leg or in the stomach, for example, not trying to kill them, you know that by doing that action it can have a really serious outcome or consequence. So that could be considered you having a guilty mind or some sort of intention, I guess, to commit the crime. So when we are proving if a crime has occurred, we want to always treat it, I guess, like a chain. We want to make sure that there is a link or a clear connection between the act and the consequence. So what I mean by that is we want to make sure that if we're charging someone with a crime, we want to make sure that someone's action of stabbing was their reason for their death. If we can't prove a link between someone's action and someone's consequence, we can't charge them with a crime. So we want to make sure we prove that this is how this person died. It was from the person's actions or the person's actus reus. Moving on to what's known as a strict liability crime. These are the only types of crimes where you don't need to prove the mens rea or that mental element of the crime. So all you need to do if the prosecution was proving a strict liability crime is they basically just need to prove that it happened, but they don't need to prove whether there was any intention, reckless indifference, or anything like that. So I always think about serving liquor to underage people is a nice easy one to remember, but also things like many traffic offences like drink driving or running red lights, prosecution never ever has to prove the mens rea there, they just have to prove that you did it. So how they might do this, for example, is on the side of the road, they might give you a blood alcohol concentration test or a breathalyzer, and if you're over the legal limit, then you'll be charged with drink driving. All right, last three is what's known as Dolly Incapax. So our age of criminal responsibility in Victoria is 10. So basically anyone under the age of 10 is deemed not to possess intention to commit a crime, and they technically can't be charged with a crime. So basically it's assumed that when someone turns 10 years old, they're now seen as finally being mentally capable of knowing what they're doing. But there is a bit of a twist to this. When a child is between the ages of 10 to 14, they're basically seen as under the principle of Dolly Incapax. And what that means is that we need to assess them on a case-by-case basis. So in conclusion, what I mean by that is anyone under the age of 10 cannot be charged with a crime because they're seen as not being able to possess intention. Under ages of 10 to 14, they can be assumed to commit a crime, but it's on a case-by-case basis because they're trying to see whether that child or whether that person aged 10 to 14 was actually mentally capable. So that's a bit of a confusing one. So apologies if that doesn't make too much sense. Moving on to the burden of proof. The burden of proof, essentially what you want to see in something like your answer is who has the responsibility to prove that someone has committed a crime. So in a criminal case, every single time, 100% of the time, the burden of proof or the responsibility always rests with the prosecution. And I want to stress this blue part here. I know my head's in the way a little bit here, but basically the burden of proof means that they have the responsibility to prove that he or she did not commit the crime, and it's not the accused's responsibility to prove that he or she didn't commit the crime. So when police charge you, when they go and investigate the crime, they find suspects, they get evidence and get everything together, they will present you and bring you to court, but they are the ones who are responsible to prove in court that the person did do what he or she is accused of doing, not the other way around. So it ties back into our definition at the start, remembering that we are always presumed innocent until proven guilty. But I guess what I really want to stress here is that in your answer, when you're talking about the burden of proof, you want to stress this word here. It's about the responsibility. They have the responsibility to prove you did the crime. All right. Second last slide for this video. The last one concept we need to know is the standard of proof. And what that means is that once we have proved a crime has occurred, say for example, once we've proved that a murder has occurred, we want to prove that that murder has occurred beyond any reasonable doubt. So what that means is that our standard of proof is that we want to make sure we prove a person guilty beyond reasonable doubt. So this definition here in blue is what you really want to focus on here. We want to make sure, once again, there's no reasonable doubt in the jury's mind that a person did in fact commit the crime for which he or she is accused. So basically what that means, if there is any doubt in the judge or the jury's mind that a person may not have committed the crime, they must be found not guilty. So really want to stress that there. We want to make sure there is no doubt whatsoever. We can confidently say this person did commit the crime. And it's a really important principle to have because it helps to prevent us from falsely imprisoning people. So we really want to make sure we uphold this standard. All right, just to round out this video, a few key points is that, remember, we have, that should be 5, we have, that should be 4. We have those 4 purposes of criminal law, so the 4 Ps. Next, we need to remember that every single one of us here in Australia has what's known as the presumption of innocence. So remember, you're always treated innocent until the prosecution can prove you guilty. And then just remember, we have 2 elements of a crime: the physical action, or the actus reus, and the mens rea, or the mental element. We have strict liability crimes. So these ones do not require the prosecution to prove the mens rea, such as drink driving. We have the age of criminal responsibility, or dolly income tax. What we talked about is 10 in Victoria, and we guess we want to talk about why that might be so important. And then lastly, we have the responsibility or the burden of proof resting with the prosecution. And finally, we also have the standard of proof, which once again means if we are proving someone guilty, we must make sure we do it beyond any reasonable doubt. So I'll see you guys in the next video.